Hi, everyone. I'm so happy to have Danny Fein here for our February Birth Speaker Series. Danny is an estate planning attorney and founder of Infinite Will, a law firm designed specifically for parents with young children. Danny lives in Summit Park with his wife, Michelle, and their 18-month-old daughter, Ella, and we are very excited to have you teach us all about estate planning. So, Danny, take it away.
Thank you so much, Kayla. Thanks for having me. Michelle and I and our daughter Ella have gotten so much out of being a part of High Family Collective. So hopefully this will be a helpful conversation and very happy to answer questions. So hope that hope that this will be kind of a dialogue. Um, so I'm excited to talk with you about something that I think is incredibly important, but often neglected, and that is estate planning for new parents. I know it's not the most uplifting topic. We're essentially talking about planning for your death, but it's one of the most important things you can do as a new parent. So today I hope to explain just why it's such a crucial task and to give you a roadmap for getting it done. So to start, I'm just going to outline what we're covering today. We'll go over three main areas. Number one, why you need an estate plan, particularly as a parent of young children. As a parent, your needs are unique and the stakes are really high. They're higher than for most people. Second, we'll go over the key estate planning decisions, specifically who would care for your children and who would manage assets on their behalf if you're no longer able to. These are the two big decisions that often cause people to procrastinate. And I'm going to go over some factors for who to consider naming in those roles that hopefully will make them a little bit easier to think through. And third, the mechanics of inheritance. So how property actually gets transferred after you die. This is the nuts and bolts that hopefully will help you understand why certain approaches work better than others. Um, as I mentioned, I've intentionally kept this presentation relatively brief because I'd love to answer questions that people have. For anyone watching this on a recording, you can always reach out to me directly. Very happy to help. So before we dive into the specifics, let's start with a fundamental question. What exactly is estate planning? So I think most estate planning attorneys would answer this question by listing the various documents that might typically comprise a legal estate plan. But in my view, those documents are part of a larger project. And that project is planning for the world that will continue to exist after you die. So to me, it's not just about distributing your stuff. It's about making plans for a world that you won't be in, but that your loved ones, and for this community, especially our children, will still inhabit. So that sounds like a massive project. And obviously, as new parents, we're incredibly busy and we'll probably never have less time to tackle it. So I'd like to look at how to approach it, how to approach this project in a structured way. So I like to think about estate planning for new parents as having three levels of priority, represented here as a pyramid. So at the bottom, forming the foundation, is what I call foundational planning. This is the urgent stuff, the things that absolutely need to be in place as soon as possible. This includes naming guardians for your children in your will, creating a trust to manage your children's inheritance, and having adequate life insurance or other savings to provide for your children until they become self-sufficient. In the middle is logistical planning. So once you have your foundation in place, you can start to focus on making it more practically workable by doing things like sharing your plans with key people, organizing important documents like insurance cards, bank account statements, lists of credit cards, writing guides or letters to help those who would step in for you. And at the top is legacy planning. So this is about passing on more than just money, things like planning for heirlooms and meaningful possessions, considering giving to charity, and preserving values and stories for future generations. Ideally, a comprehensive estate plan would include all three levels. But if you're a new parent, the reality is that you probably are incredibly busy, don't have much free time. And so to me, your focus should be on that foundation, getting the essential legal documents in place and securing life insurance. And then you can build on that foundation over time. But I think this raises an important question. If estate planning is so important, especially for new parents, why is it that the vast majority of young people don't have an estate plan? And I think it often comes down to a simple cost-benefit analysis, where the expected value of creating an estate plan just doesn't seem to outweigh the costs. On the cost side, we have money, number one. So working with a lawyer to draft your estate plan generally costs somewhere between $2,000 and $6,000, depending on where you live. If you were to shop around in Park City and Salt Lake City, I think you'd find that most attorneys charge in the range of $3,000 to $5,000 for a foundational trust-based estate plan. There's kind of no getting around it. It's expensive. Number two is time. You have to make appointments. Most attorneys are only open during business hours. You might need to take out off of work, find childcare. You have to gather information, make difficult decisions. And especially if you're trying to address those lower priority levels, the logistical and legacy components, those can be particularly time consuming. And then there's just the discomfort. Obviously, thinking about your own death isn't exactly fun. And then on the benefit side, we have a simple formula. The value of having a plan in place if you die, multiplied by the chances of dying soon. For most young, healthy people, this calculation doesn't strongly favor going out and getting an estate plan. The odds of dying anytime soon are low, and there are a million other things competing for your time, attention, and money. This is why the vast majority of young people, even those who are financially sophisticated and responsible, don't have estate plans. But I would argue that having children changes this calculation dramatically, and specifically this piece, the value of having a plan. Once you have a kid, the value of having a plan skyrockets because now we're not just talking about the orderly transfer of your assets or making administrative tasks easier on your family. We're talking about who would raise your children and how they would be provided for. So, in other words, the potential downside of not having a plan becomes so significant that it outweighs those, significant costs. Now I'm going to zoom in on the foundation of our pyramid because this is what I think new parents should focus on first. And specifically, let's look more closely at the two key legal aspects of a foundational estate plan: guardianship and inheritance management. So, number one reason why every parent needs a trust-based estate plan is to choose a guardian. So, the place where you choose a guardian is in your will. A guardian is the person who would care for your children if you no longer can. It's arguably the most important legal decision you'll make as a parent. Without a will that names a guardian, a judge will decide guardianship based on what they determine to be in the best interests of your children. They'll likely choose a family member, but it might not be the person you would have chosen. And there could be a custody battle, conflict between multiple family members who all want to step in and help, which is really the last thing that anyone needs in already a terrible situation. The second reason why every parent needs a trust-based estate plan is to leave assets in trust for your children. So in a trust, you can choose who should manage assets on behalf of your children until they're financially mature enough to manage it themselves. You can specify ages when they should receive portions of their inheritance, or an age where they can take over the role of trustee, and you can provide guidelines to your trustee for how the money should be used. Without a trust, similar to guardianship, a judge would decide who should manage your children's inheritance. And that person would be required to report to the judge at least annually, which adds a lot of administrative overhead. And probably most importantly, each child would receive their inheritance outright as soon as they turn 18, which I imagine is not what most of us would plan for our kids. So that's the main reason why I always recommend not just getting an estate plan, but getting a trust-based estate plan if you have young children. And I actually won't draft an estate plan for parents of minor children that doesn't include a trust. I see it as just totally fundamental to what we're trying to achieve. So if you're convinced now that you need an estate plan, you might be thinking about who you would choose for each of these roles: the guardians who would care for your children, and the trustees who would manage their inheritance. The choice of guardian is often the most emotionally charged aspect of estate planning for parents. It's the hardest choice to make, and it's the most common reason people delay making an estate plan. I've had so many people tell me, I know I need an estate plan. We've been meaning to do it for years, but we just can't agree on or we can't think of the right person to act as guardian for our kids. And what I would tell them is that any choice that you make is better than leaving it to chance. And you can always change the nominations later. It's very common. Many people will change who they nominate as guardian as circumstances change or relationships evolve, or if you move or the guardian moves. Um, there's no reason why it can't be updated many times over the course of your life. When choosing a guardian, here are some factors that I recommend considering. Number one, shared values and parenting philosophy. To me, this is often the most important factor. You want someone who will raise your children with values similar to your own. Number two, their existing relationship with your children. Obviously, the more there's an established bond in advance, the easier the transition will be for children who have just lost their parents. Number three, the age and health of the guardians. Guardianship, if you have young kids, it's obviously a long-term commitment. So it's worth considering whether the person you're considering is able to keep up with young children and if they're likely to be healthy enough to see your children through to adulthood. Number four, location and lifestyle. Would your children need to move or change schools? How disruptive would the transition be? And number five, their willingness to serve. This is really crucial. I definitely recommend having conversations with any potential guardians to make sure that they're willing to take on the responsibility and understand what it means. I found that many parents struggle because no one person or couple seems perfect, and that's totally normal. Remember, you're not looking for perfection. You're looking for the best possible option in a horrible situation. You can nominate different people as backup options as well if your first choice isn't available or willing when the time comes. While guardianship addresses who will raise your children, we also need to consider how their financial needs will be met. So let's turn to the inheritance side of the equation. I'd like to go into a little more detail about how a trust works. As I mentioned a few minutes ago, if you don't have a trust-based estate plan, the judge will select someone to act as what's called a conservator, the person responsible for managing your children's inheritance. And the reason for that is that children can't legally hold title to property until they turn 18. So someone needs to be appointed to manage, money and assets on their behalf. The downside to a conservatorship, in addition to the fact that it's a judge choosing the person instead of you and your family, is that it's restrictive, it's court supervised, it can be expensive and inflexible. And of course, the judge might not choose the person who you would have chosen. And again, when your children reach the age of 18, they'll receive whatever remains of their inheritance all at once with no restrictions. On the other hand, if you set up a trust, the trust document names a trustee who will manage the inheritance for your children's benefit according to your instructions. You can include detailed provisions about when and how your children receive their inheritance. So, for example, you could say, I want my children to receive half at age 30, the second half at age 35. You can keep it more flexible and say at age 30, my child can take over as trustee and they can decide whether to leave assets in trust or to withdraw. And you can also provide guidelines to the trustee for how you want the funds to be used. So in terms of naming a trustee, these are some factors that I think are worth considering. Number one is financial responsibility. Ultimately, this is a job that requires managing money. So I definitely recommend choosing someone who manages their own money well and who wouldn't be overwhelmed by having to handle your children's inheritance over time, in addition to their own finances. Number two is their relationship with your kids and with your kid's guardian, if that's someone different than you're selecting as their trustee. I recommend selecting someone who knows and cares about your children, but who could maintain boundaries when making financial decisions on their behalf. Number three, you want to find someone who consistently makes thoughtful decisions, someone with good judgment, and who will apply your instructions rather than substituting their own preferences. Number four, similar to uh, consideration for selecting guardians, you want someone who shares your values, and in this case, specifically values about money. So ideally, you'll find someone whose views on education, work, independence generally match yours so that they'll be more likely to distribute funds in ways that you would have or that support your priorities for your children. And number five, again, willingness to serve. Anyone you're naming in one of these roles, it's ideal if you've had conversations with them before doing so, just to make sure they understand what the role involves, that it's a long-term commitment, uh, involves making important decisions, and yeah, that they're willing to take on this responsibility. Many parents choose different people to be the guardian for their children and the trustee for their children's trusts. One reason you might do that is if the person you think would be the best one to raise your child just isn't that great with money or, isn't the most organized. And there's someone else in your life who you think would be better suited to the particular responsibilities of being a trustee. Another reason might be if you're really close to family members on both sides of your family and you want someone on each side to have, kind of a formal legal stake in the upbringing of your children. On the other hand, it's also common to choose the same person for both roles. It's really totally up to you. All right. So in order for your trust to work the way that you intend it to, your assets need to be transferred into your trust one way or another. So here's the second pyramid of the night that illustrates how different types of assets pass to beneficiaries after the owner dies. The crucial thing to understand is that we're working through a process of elimination here. So, for example, assets will only pass by the terms of your trust, which is the third level down here, if they don't pass by beneficiary designation, the second level. In other words, the higher levels here override the levels beneath them. So let's go through what each of the levels means. At the top of the pyramid, we have title or joint ownership. So anything that you own jointly with right of survivorship passes automatically to the surviving owner. This commonly includes things like a house that you own jointly with your spouse or partner, joint bank accounts, or investment accounts where you've specifically set them up as joint ownership with rights of survivorship. Just below that are beneficiary designations. So assets like life insurance, retirement accounts, and transfer on death accounts pass directly to named beneficiaries. And in many cases, that simply means signing on to your retirement account, logging into your retirement account, clicking on change beneficiary, and you can see right there who is designated at the moment to receive those assets when you die. Next up are trust assets. So these are assets that have been titled into the name of your trust during your life, and those pass according to the trust terms without any court involvement. But for this to work, you have to have actually transferred ownership of those assets into your trust during your lifetime. So, for example, changing the deed on your house, or retitling bank accounts, or updating stock ownership records to show the trust as owner rather than you as individual. Below that, we have your will. Assets that pass through your will go through a process called probate. Probate is a supervised legal process, a court procedure, where your representative inventories your assets, pays your debts, and then distributes what remains according to your will. When you have a trust-based estate plan, you'll use what's called a pour-over will that directs all of your assets to be transferred to your trust after death. The pour-over will ensures that all of your assets ultimately make their way into the trust to be managed by the trustee who you selected and according to the terms that you've written into the trust. And then at the very bottom, we have intestate succession. This is what happens if you die without a will. In that case, Utah state law determines who gets what. And as you might expect, it rarely matches exactly what you would have wanted. So again, to recap, simply drafting a trust and a will doesn't guarantee that all of your assets will pass as you intend them to. It's particularly important to think about the second section from the top here, the beneficiary designations, because there's certain types of assets that many of us have, such as retirement accounts and life insurance specifically, that only pass based on who you've designated as a beneficiary. So no matter what you've written in your will, no matter what you've written in your trust, you also need to take a look at those accounts and make sure that the beneficiaries you've selected are in line with the rest of the plan that you've designed. I'd like to stop for now and see if there are questions. It's kind of a technical topic. There's a few other points I'm going to make at the end, but if anyone has any questions now about anything related to estate planning, very happy to try to answer them.
Hey, I have a question.
Sure.
This is Sophie. So I have what you just called a pour-over will, right? And I just want to understand a little better. The way it was explained to me that I don't actually need to establish this trust as a legal entity during my lifetime, right? So it will be established by beneficiaries, or beneficiaries are the trustees, rather, right? Like in the event of my death. Is that accurate? See, I always thought it was strange.
So thanks for your question. That is not exactly accurate. So is it possible that whoever told you that or whoever drafted your plan that there's a trust that's created in your will? So there's something called a testamentary trust. So on the one hand, you can draft a trust that takes effect during your life. So the type of trust we've been talking about is called a revocable living trust. And the living portion of that means that it's created while you're alive. Alternatively, you can just have a will and basically embed the trust document within the will. And in that case, the trust doesn't exist until you die and the will becomes effective. Does that ring a bell, or is that not?
Yeah,
Yeah.
that's the way I understood it. And so basically the will just says all of these assets go into a trust. And then
Yes.
all of the accounts have the trust, the estate of the insured as, or like the estate of such and such of Sophie Karp as the beneficiary.
Yep. So that's a perfectly valid way of creating an estate plan. As long as you have a trust, whether it's a testamentary trust created within your will or a living trust that's created separately, it still accomplishes the most important goal, which is, to me, preventing all of your assets to pass to your child as soon as they turn 18.
Right.
The downside to having a testamentary trust as opposed to a living trust, there are a number of downsides. I think the biggest one is that some institutions, some banks, and some life insurance, insurers won't recognize a testamentary trust as a beneficiary. So, as you mentioned, a part of any trust-based estate plan would be going through those types of assets that have beneficiary designations and designating the trust as a beneficiary so that the assets flow into the trust and pass according to the terms of the trust. Some institutions say, well, the trust in your will doesn't actually exist at this moment. It only springs into existence when you die. And therefore, we're not going to let you name that trust as a contingent beneficiary. Most institutions will allow you to do that, but some won't. And to me, if you're drafting the trust, in theory, it's the same trust that you're drafting, whether it's a part of the will or separate. For that reason alone, I like to draft it as a separate living trust to make the beneficiary designations simpler. And it gives you the option, if you want to, of titling assets into your trust while you're still living.
Okay. Thank you so much. Appreciate it.
Of course.
Hi,
Danny?
I have a question. Oh.
No, go ahead, Brooke. You go.
Okay, just really, I don't think it's a long question. Can wills and trusts both be challenged by family members or courts, and if so, is one less likely to be challenged, or are there degrees?
Sure. Yeah, I mean, there are ways that someone could challenge both a will and a trust. To me, any estate plan that any of us are considering, I think should have both a will and a trust. Um, Wills are a public, when a will is probated, it's a public process. Um, to me, that introduces maybe some more risk that someone might come out of the woodwork to challenge it. With a trust, the person who typically would challenge something to do with the trust is the beneficiary. So imagine your child is now, 22, and you've written the trust so that until they turn 30, the trustee that you've selected is totally in charge, and your child thinks that that person is doing a bad job or being dishonest. They, as the beneficiary, would have the right to go to court and ask a judge to basically enforce the terms of the trust and force the trustee to do what they're required to do. Um, does that answer your question?
It does. Yep. Thanks.
Great.
Danny, this is kind of along those lines. I had a mom text me a question to ask you.
Great.
So she said, what documents would we need to have if we have family who have threatened CPS and taking away our son? We have narcissistic family who don't like our lifestyle choices, and we want to ensure our son is protected from them.
That's a really tricky situation. I think you would definitely want to work with an attorney who has experience dealing with that particular type of situation. So I personally haven't dealt with CPS myself. I would say for sure, if you think that your family situation is such that there's likely to be a conflict, either between family members or between a family member and what your wishes are, then having a plan just becomes that much more important. That doesn't guarantee that there won't be a challenge, but the whole idea behind a will and a trust is that it allows you to write down your wishes in ways that are legally enforceable. And if they're well drafted, again, it doesn't mean that they'll escape any challenge, but they should be able to survive them at least. Um, Guardianship in particular can be trickier. That always goes in front of a judge. There's always an opportunity for, family members to come and, share their own opinions. But to me, I think the clearest answer I can give is if you're in a situation like that where there's going to be family conflict, definitely speak with an attorney and make sure that you have a plan in place, because that's the best way that you can protect yourself and make it most likely that your wishes are carried out.
Thank you. I will pass that along.
Awesome.
I have a question for myself now, actually.
Sure.
Is it typical when you're picking guardians for both that and like the trust? Say you wanted someone else in charge of the money. Do you do numerous people, like first choice is A, second choice is B? How does that work?
Always. So
Okay.
I always recommend choosing at least one backup for each of those two roles. Um, things happen. It's possible something happens to the person that you've selected as trustee or guardian between the time that you execute your plan and have time to update it. It's possible their life has just changed and they're not able to take on this task. Excuse me. So I always have my clients name, in the case of a trustee, actually two backup options. Because again, everyone in this group, our children are young. We're talking about potentially 15, 20, 25-year long commitments that we're asking these people to make. And we want to make sure that, you cover all of your bases. It's impossible to predict the future. So my general philosophy is we want lots of flexibility in the plans, and we want to cover every possible contingency that we can think of.
Hey, this is Sophie again. Now that I'm listening to this, I have another question.
Sure.
So I have two co-trustees named in my will. If, like, let's say if a situation is that only one of them is then like at the time of the event is still willing to perform those duties. Is that okay, or do they need to be somehow named as a backup to each other?
Yeah, that's definitely okay. So it's very common to name co-trustees, especially for older clients who have adult children and have multiple adult children. Sometimes they'll name, if you have two kids, you might name them as co-trustees or, co-personal representatives. And there are different ways that you can do it. So you can write a trust, or you can write that section of a trust to say, these are my two co-trustees, and in order for either of them to take any action, they both need to agree to it, or all three of them need to be unanimous. Or you could say, if there's three of them, there needs to be a majority. Or you could say any one of them can act on their own. So it really depends what you're trying to achieve. If you're trying to achieve flexibility, basically just naming more than one person who can take on those roles, without needing them to act together, then you would write it that way. If you're trying to make it more of a, combined effort, where everything needs to be unanimous, then you can write it that way as well.
All right. Thank you.
All right, I'm going to share two more slides on the logistical planning and legacy planning pieces. So just to reiterate, I think for most of us, it's unrealistic to think that we're going to tackle this at this moment in our lives. But I find them really interesting, these components of estate planning. And so just really briefly, in case anyone else finds it interesting, wanted to share some thoughts. So logistical planning, what I'm talking about here is things like sharing your plans, and specifically sharing them in a way where the people that you've named to these key roles can find them in the situation where you're incapacitated or you've passed away. There are a number of really cool services out there, and I'll send some links that maybe we could post under the recording. There's a great product called Trustworthy. It's trustworthy.com. And basically what that allows you to do is to upload not only your estate planning documents, but also any other important, they call themselves, I think, the family operating system. So you upload your insurance IDs, your car registration, your bank statements, and it basically keeps everything organized in a way that if someone needed to step into your shoes, it would all be right there. It also makes life a little bit easier while we're still around. It also includes things like funeral plans. There are some really cool new options for funerals and burial that didn't exist even like 5 years ago. So one that I find really interesting is a company called Recompose. So they actually developed a system called human composting. And the idea is that over a course of, I think it's either a couple of weeks or a couple months, your body turns into compost, and they'll deliver that compost to the family, and you can use it to plant something in your yard. You can donate it to a national forest. And it's been interesting to see they've been kind of going state by state and lobbying state legislatures to legalize it. And I think it's now legal in maybe 10 states, not Utah yet, but maybe someday. On the let's see, other logistical planning. Things like creating a life admin guide. So I like to imagine, if I were going away on a vacation and the grandparents were coming to watch my daughter, uh, this happened just a couple weeks ago, and I ended up writing like a 7-page guide for, how to feed her and doctor's phone numbers and everything you might need to care for my daughter for a weekend. Obviously, that type of guide would be incredibly helpful to have for someone who is taking over as guardian, and you could write something similar to someone who would be taking over as trustee. And again, that kind of preparation is also helpful in the case where you're incapacitated. So you haven't passed away, but you're just not able to take on these tasks yourself. This might not be the moment that all of us are able to take on that task, but some really interesting tools out there for that as well. And then the legacy planning, this is actually what I'm kind of most personally interested in. This is things like creating an ethical will. which is a non-legal document that shares your values or life lessons or hopes for your children. There's actually like a thousands-year-old tradition of writing ethical wills, and it can be really therapeutic and just kind of clarifying, thinking about heirlooms and trying to preserve them for future generations. So now that we have computers and phones, there are really interesting ways to pass down digital heirlooms. So there's a company called Artifact that makes it really easy to basically take photos of heirlooms and attach information to them, that kind of makes them more interesting to, the people, your descendants, who otherwise might, kind of look around a house and see tchotchkes around and not really know what they mean. There's also some really cool services out there around preserving stories and things like that. There's a company called Storyworth. I think there's probably 5 or 6 now that will facilitate interviews and then either print them into a book or produce them into a podcast. Those two are probably better fits for older population that are kind of more in that phase of life. But I find it really interesting, and it's something that I'm hoping to incorporate into my practice over time. So I'll include those links. I'll send them to Kayla, and if anyone's interested, check them out. And yeah, if anyone has any other questions, happy to take them. Otherwise, thank you everyone for being here late at night. I appreciate the questions that you asked. And once again, for anyone watching the recording, please feel free to reach out to me. My email address, where is it? Danny@infinitewill.com. And yeah, thanks again, Kayla, for having me.
Thank you so much. This was very informative.
Awesome. I appreciate it.